and welcome everyone to the ins and outs of related proceedings before the ITC and PTAB, part of Virtual Patent Gateway's PTAB Practitioner series, hosted by Virtual Patent Gateway founder Ashley Chung. Virtual Patent Gateway, VPG, was founded in January 2020, right before the pandemic, and Ashley has a passion for supporting PTAB practitioners and is committed to developing a growth mindset within VPG. Joining us today is Hoang, co-managing partner at Reichman, Jorgensen, Lehman, and Feldberg, LLP, and her associates, Eklem and Connor Houghton. Khue has over 20 years of experience in high-stakes patent infringement and licensing disputes. She is a member of the National Asian Pacific American Bar Association and CHIPS, a national nonprofit organization that advances and connects women in technology, law, and policy. This webinar will be recorded for future use. We've applied for Virginia CLE for 1 hour pending approval. Ashley will notify you once those are approved. There will be a short Q&A at the end of the presentation. And with that, I'll hand things over to Khue.
Thank you very much, Caitlin. Good afternoon, everyone. I just wanted to start by thanking Ashley and her team for organizing this. We very much appreciate the opportunity. My colleagues, as Caitlin mentioned, are Connor Houghton and Eklem. They're both associates with Reichman Jorgensen, and they are both deeply experienced in both ITC and PTAB proceedings, and you will be hearing from them in a little bit. But I just wanted to open up the presentation by giving a brief overview of what we hope to accomplish today. We're talking about related proceedings in front of two very popular forums for patent-related disputes. One, the ITC, is obviously a forum that patent owners often make use of for enforcing their patents. And the other, the PTAB, is a forum for which many challengers want to challenge the patentability of patents. And so this push and pull between the two creates expected tension. And what we plan to dive into today at a relatively medium-high level is to address some of the tension that exists between the two, and in particular, to address what appears to be a rising tide of strategic decisions that need to be made when a party, whichever side of the V you're on, is dealing with parallel proceedings in front of both fora. So the ITC, as I'm sure everyone is well aware, is a forum that provides relief in the form of exclusion orders, which can be devastating for a respondent. And so respondents often try to gain leverage by filing IPRs in front of the PTAB, challenging the patentability of the patents that are asserted against them in the ITC. Now, these parallel proceedings, as I mentioned, are common, but unlike district courts, which often also have coexisting with PTAB proceedings, unlike those district courts, the ITC has very clearly stated that they're not interested in delaying or staying investigations pending PTAB proceedings. They view the legislative mandate as being absolute, and that means working through ITC investigations as expediently as possible. The PTAB, conversely, has become increasingly comfortable in the last couple years issuing what are known as discretionary denials under Section 314A. And the Fintiv Factors. I think a lot of people become familiar with those 6 factors as well. And a lot of these discretionary denials are not on the merits, they're on procedural grounds. And that number has mushroomed to about 38% of all discretionary denials. So it's a very significant number. And so if you happen to be a respondent facing an ITC investigation, you have a narrowing set of choices in terms of where to put your resources. Do you want to spend time and money on IPRs, knowing that it's very unlikely to affect the timeline of your ITC, and also knowing that the PTAB may deny institution, which is unreviewable for procedural matters, or do you focus on the investigation and throw your resources behind trying to invalidate patents there? And the answer isn't always very straightforward. And so to shortcut what was supposed to be a relatively brief introduction, we're going to talk about both forums, give you a little bit of background on each, and then spend some time focusing in on particularly the strategies that a party can exercise, whether you're a patent owner complainant or whether you're a petitioner respondent, and how that might play out. So without much further ado, I'm going to hand this over to Phil to give you a little bit of information about the PTAB. Phil?
All right, thanks, Khue. Good afternoon, good morning, everyone. Again, my name is Phil, and I'm going to go ahead and get us started with some background and an overview of proceedings before the PTAB. So the PTAB, what is it? The PTAB is the Patent Trial and Appeal Board of the U.S. Patent and Trademark Office. The PTAB is a body of administrative patent judges, or APJs, that decide appeals from decisions of patent examiners. But it also adjudicates the patentability issues raised in AIA challenges that are brought by third parties in post-grant proceedings. Before the passage of the American Invents Act, or the AIA as we call it, this body was known as the Board of Patent Appeals and Interferences, or BPAI. So relevant to our discussion today, the types of trials conducted by the PTAB under AIA include inter partes review, or IPR, formerly covered business method review, or CBM, which has recently hit its sunset period, and post-grant reviews, or PGRs. And they also handle derivation proceedings as well, but we will not be focusing on those today. According to US PTO statistics, in 2020, 95% of the petitions that were filed were for inter partes review, as opposed to PGR or CBM. And similarly, in the first 2 quarters of 2021, over 90% of the petitions were for IPR. So needless to say, IPR petitions typically far outpace the other types of AIA review petitions by a long shot. So the PTAB itself is located in Alexandria, Virginia, at the PTO's main campus on Delaney Street in just outside of Old Town, Alexandria. But even before COVID protocols and remote work that we're all kind of accustomed to now, the PTO has sort of a history of affording telework privileges, and so it was quite often for even before COVID to have APJs appear at hearings virtually. So some of them are located throughout the country. Let's see. So let's go on ahead to our next slide. Talk a little bit about the PTAB jurisdiction. So as I mentioned earlier, the PTAB has jurisdiction over several types of proceedings, including IPRs and PGRs. From each type of proceeding, before each type of proceeding, IPRs, PGRs, a member of the public can challenge the patentability of patents claims by filing a petition. But even if the petition meets all the statutory requirements and is otherwise proper in that regard, the board still has authority to deny petitions under its discretionary authority under 35 USC 314A. So what does that mean? So the board's decision to use its discretion is broad, first and foremost, but it is guided by a set of factors known as the Fintiv Factors, which we'll get into later. But just to complete the circle here, that discretionary authority covers the range of proceedings, including IPRs, PGRs, and formerly CBMs. So moving forward, there are a few advantages to petitioners when they file petitions at the PTAB. The AIA trial proceedings were intended to be an alternative to district court litigation, and there are several key differences between district court litigation and PTAB proceedings. Among those are the limited discovery that takes place in the short timeline to completion. So for example, PTAB trials are typically concluded within 12 months of an institution decision, or 18 months overall, as compared to district court litigation, which can take, depending on which jurisdiction, can take multiple years. And the idea was that the reduced discovery and time saving would lead to a cost saving and help parties reach the end of their disputes in a faster and less expensive manner. Another advantage, though, is one of the differences between the PTAB and district court and ITC proceedings is that patent owners' burden of proving unpatentability at the PTAB is lower than in district courts at the ITC. Specifically, unpatentability at the PTAB, you'd only be proved by a preponderance of the evidence, whereas in district court and the ITC, the burden of proof is by clear and convincing evidence, which is higher. That said, the board decides whether or not to institute a petition by a different standard yet, which is perhaps a lower standard, but that standard only requires a reasonable likelihood that the petition will prevail with respect to at least one challenge claim. So even if the standard is met, however, the board may still use its discretion under 314A to deny the petition. But at the outset, it's important to note that the barrier to entry is a little bit lower at the PTAB to challenge patentability as opposed to ITC or in district court. So under the board's reasonable likelihood standard, petitions have instituted at a rate of about 60% since 2016, with some reasonable fluctuation throughout the years. So that's above 50-50 odds of getting instituted, which is not bad, given the benefits that await the petitioner if instituted. So another characteristic of the PTAB is that it typically favors petitioners in that APJs are specialist judges. They have technical backgrounds that meet certain criteria set by the PTO, and many of them are former patent litigators and practitioners. So, technical and legal details that may otherwise get lost in translation in other jurisdictions oftentimes do not, which is a bit of a benefit to patent owners. I'm sorry, to petitioners who want to see their case go forward. Lastly, the petitioners have a bit of an advantage in that many district courts are amenable to staying their litigations pending the outcome of an instituted proceeding. So if a petitioner is also a defendant in parallel litigation in district, and if they seek a stay of the district court proceedings, they have pretty good odds of getting it. And so if a stay is an important part of your district court litigation strategy, then that's an important benefit that filing at the PTAB has for petitioners. Some disadvantages. So at the PTAB, there are some disadvantages for petitioners, including the fact that the scope of unpatentability challenges that could be brought are limited. So for IPRs, they're limited to challenges under sections 102 and 103. So patentability challenges based on anticipation or obviousness. And those are further limited to, they can only be based on prior art consisting of patents and printed publications. So whereas in the district court or ITC, a defendant may bring invalidity grounds based on other types of prior art, such as systems, prior use, on sale bar. Those types of things are not permissible for petitions before the PTAB. And another related disadvantage is that if the petition is instituted and goes all the way to a final written decision, and if it is unsuccessful, the petitioner is statutorily stopped. They're bound to, and they're not allowed to raise any invalidity claims that they reasonably could have raised in their petition. And what that means is for IPRs, any printed publication prior art that could have reasonably been raised in their petition, if unsuccessful, the petitioner is not allowed to bring such claims in the parallel cases. For CBMs and PGRs, it's a little bit different story and a little bit more dangerous. So we use PGR as the example. In a PGR, unpatentability grounds can be raised under, in addition to sections 102 and 103, can be raised under 101 and 112. And so while that's great for petitioners, we have a little bit more to work with there. The downside is that the estoppel is potentially much greater. So, it's important to note that while there are much fewer PGRs that have gone through the process than IPRs, there have been at least some district courts who have interpreted the estoppel statutes to mean essentially what they mean in their plain language, which is any ground that reasonably could have been raised is estopped. So for example, at least one court in the Eastern District of Texas has found that where a petitioner, they brought a PGR asserting only grounds under section 101, after the PGR proceedings were finished, they were stopped from raising grounds under prior art invalidity, including under sections 102 and 103, even though they didn't raise them in their PGR. So the fact that they reasonably could have raised certain prior art grounds means that they were therefore stopped from bringing them in the district court. So it's significant, it's important, and perhaps it's one of the reasons why we see much fewer PGRs. But the other reason also relates to the fact that PGRs can only be filed within the short 9-month window between when a patent issues or after a patent issues. You have 9 months to file a PGR, after which PGRs can no longer be filed. So between those two things, those are the reasons why we tend to see much fewer PGRs than IPRs being filed. So on to petition requirements. Petitions for AIA review must meet several requirements prescribed by statute and other rules. Petitions must identify with particularity each claim challenged and the grounds on which the challenge is being raised. It must include the evidence supporting the ground, but also petitioners must identify how the claims are to be construed, which is an important requirement. Which, you know, it's an important requirement in and of itself, but it's important to note that since 2018, the board has now been required to construe claims under the Phillips standard, whereas before they were using the broadest reasonable interpretation, which is what patent examiners use when they examine patents. But since 2018, the board has been required to follow the ITC and district court and construe claims under Phillips. Let's see. So, you know, another important thing to note is that the evidence that may be submitted to support a petition can include things like expert testimony submitted in the form of a declaration. So this all becomes part of discovery, where if a petitioner or any party that submits an expert declaration, their expert is then may be subject to deposition, which takes place during the discovery period. And that's just another layer of, you know, what to expect and things to consider when gathering up your petition and the evidence to support it. While this is not really a requirement, parties may request an oral hearing. And if they do, it's important to note that new arguments cannot be raised there. So I can't really stress this enough. It's very important for petitioners to consider all of these things, including the scope of evidence and arguments, well in advance of filing their petition, because the petition sort of sets the stage for what will be argued and eventually argued before the board. So all important things. Remedies. So moving on to remedies, the remedy is cancellation of claims. A successful petition through final written decision will result in the cancellation of claims that are found unpatentable. And those cancellations are binding. So once claims of a patent are found unpatentable by the PTAB, they are no longer patentable and probably should not be asserted in any other jurisdiction. Jurisdictions will take the PTAB's orders as precedent, and that can be the end of patent claims. There, of course, can be appealed, but if the final determination is that the claims are canceled, that's the end of the claims. But there are other outcomes. For example, the claims can be found patentable. So at the end of the day, if the claims are found patentable, the claims are not canceled, and they live to see another day. And as we mentioned before, the estoppel provisions attached. So any future challenges, at least by the petitioner, must be outside of that. But at the same time, patent owner may amend their claims during the proceedings. They can bring a motion to amend, and this is kind of it happens frequently, but at the same time, it changes the scope of the claim. So in terms of strategy, it's important to think about what that might do to any parallel litigation going on, what that means if you have a case pending at the ITC or district court, if you have to amend your claims. But it is possible to do that during the proceeding, and sometimes that happens to avoid the unpatentability challenges. On the other hand, a patent owner may also statutorily disclaim the claims of their patent during the proceeding, which is effectively conceding that the claims no longer are effective, and that can bring proceedings to an end, or it can obviate the need for a final written decision on those claims. So if a patent owner doesn't want to reach the end of the line before a certain point, it is possible to disclaim any of the claims that are challenged. So bringing up, so I guess coming to the end of our summary here on slide 10 is shows a typical timeline for PTAB proceedings. The first 6 months constitute the preliminary phase, and it ends with the institution decision, either to institute or to not to institute. And then the next 12 months comprise the trial phase, which includes patent owner's response, petitioner's reply, all permissible discovery, including depositions. And this is that is when, if a patent owner chooses, they can file a motion to amend. If an oral hearing is requested, it takes place during that time. And within that 12-month period, all of this takes place, ending with the final written decision. Okay, so with that, I'm going to turn it over to Connor, who's going to give us an overview of ITC proceedings.
All right, thanks, Phil. Yeah, I'll just briefly give an overview of the ITC in a similar vein to the PTAB, and try to provide some of the key facets of the ITC that are relevant to this issue. So just briefly, the ITC is another popular forum for patent litigation. It's an independent federal agency located in DC. They also, in addition to patent-based cases, hear import injury, other IP import cases such as trademarks and copyrights, as well as do research, provide trade information, and update trade policy. The ITC is led by 6 commissioners who are nominated by the president and confirmed by the Senate, and they serve 9-year terms. But more relevant to the patent-based cases, there are 6, currently 5 ALJs that hear patent cases and act similarly to Article 3 judges, but are not, nominated and confirmed. But they lead the proceedings through, institution all the way through trial before it goes up to the full commission. The ITC has limited jurisdiction over patent cases only for cases where there are imported goods. The jurisdiction is based on 19 USC 1337, which is known as Section 337, which prohibits the importation, sale for importation, or sale within the US after importation of articles that infringe a valid and enforceable US patent. So ITC cases are run more similarly to district court cases than to PTAB proceedings. They have a longer discovery period and much more broad discovery than PTAB cases do. There are fact witnesses and depositions and a lot of broad-based written discovery. But all of this happens on a very compressed timeline. So I'll go over an exemplary timeline a little bit later on, but in general, the target date for an ITC case is 16 months after institution. So you can generally expect from the time the ITC takes up your case to a final decision by the full commission to be about 16 months, which is similar timeline to the PTAB, but a lot shorter than a district court where the average time is around 2.5 years.
Hey, Connor, how long on average just to the initial determination before it goes up to the commission?
Sure. So we can go over the timeline in a little bit more specifically, but it's generally around 8 to 9 months you can expect from institution till an initial determination by the ALJ. And that does vary between different ALJs. It can be more like 12 months with a trial at 8 to 9 months, but some ALJs like to get the trial and the ID out faster. Another couple of advantages of the ITC are that, as Phil mentioned earlier and Khue also mentioned, ITC investigations are generally not stayed. Recently, a couple of parties have tried to get ITC investigations stayed pending IPR, and we'll talk about that a little bit later. They have not been successful. The ITC takes its mandate to get cases done in the quickest possible manner very seriously. And so the orders that have come out of these have been pretty clear that there's almost no situation where the ITC would stay pending an IPR. And then finally, one of the biggest advantages for petitioners in the ITC is the unique remedy, which we'll go over briefly, but you don't need to prove irreparable harm to get a basically permanent injunction. The remedy is an exclusion order if you win infringement and invalidity. There are some disadvantages to filing in the ITC that people need to be aware of before doing it. There are some unique requirements, which we'll talk about on the next slide, but in general, also, there are no damages. The remedy is an exclusion order, which can be very effective against some parties, but you're not going to be able to get money from defendants. One way around that is that you can file a parallel district court case at the same time you file an ITC complaint, which many people do, but the statute allows any defendant and respondent to stay the parallel district court case as a matter of right while the ITC case goes all the way up through appeal. And so that can be a couple of years before you'll even get to start up your district court case. Some other things to be aware of that are more disadvantages are, because the remedy is limited to exclusion, there are some traditional ways that people can get around it. One is to onshore manufacturing, which isn't realistic for everybody, but some people are able to bring their manufacturing to the US. And then even if you went through this whole proceeding to get an exclusion order, it's no longer going to stop any imports if people start manufacturing onshore. Another is the risk of design around. Again, if people can get their design arounds into the case, which is a whole separate presentation, I think, then they can get a ruling that says their new product doesn't infringe, and then they can start importing that and get around the exclusion order. And then finally, because the ITC is not an Article 3 court with Article 3 judges, its rulings on infringement and validity, while very persuasive, are not actually binding on district courts. So theoretically, parties are able to, even if their patent is invalidated in the ITC, still bring a case in district court on the same patent. Now that's pretty risky, but it's a difference between the PTAB and the ITC, because the PTAB has the jurisdiction and the authority to fully cancel patent claims where the ITC does not. I mentioned earlier there are a few other specific requirements that you need to prove to bring a case in the ITC. One is called domestic industry. Again, I don't want to get into the details too much because it's probably a whole separate presentation, but you basically have to show that there is a product that practices the patent and that the complainant has made significant or substantial investments in the US related to the patented technology. Now, that doesn't mean you necessarily have to manufacture a product that practices the patent in the US. There are other ways to satisfy the DI requirement, including through licensing. But in general, it's somewhat of a difficult hurdle. And even US companies can sometimes have a hard time if they don't manufacture their product in the US, satisfying the DI requirement. So it's definitely something that you need to investigate fully before deciding you're going to file a case in the ITC. And that differs from the PTAB, where of course anybody can file a PTAB petition, even if you have no Article 3 standing or other interest in the patent. Any of you could go file a PTAB petition on a patent if you wanted to. There's no jurisdictional requirements. And then another, just briefly, requirement is the importation. So because Section 337 only covers imported articles, if something is completely manufactured in the US, then the ITC is not the right forum to go to, because you're not going to actually get a remedy that stops anything. I've mentioned the remedies a couple times. The limited exclusion order is the technical term for what the ITC generally issues. And so it's an order that's enforced by Customs and Border Patrol that stops products that are found to infringe from entering the US. There's also something called the general exclusion order, which is more difficult to get, but rather than only stopping the one party you sued from importing, it stops all imported products, even if they weren't parties to the case. And then finally, the ITC can also issue a cease and desist order, which ensures compliance with exclusion orders and stops people from selling their previously imported products that are already in the US. Now we're coming to the timeline. And so this is a little bit more detail about the question Khue asked earlier. Say we filed an ITC complaint today, and this is only typical. Different judges have different timelines, but we could expect institution in around a month at the beginning of September. There would then be a short discovery, expert and pretrial phase that would go till around May of next year. And then we would expect an initial determination from the administrative law judge in around a year from initial filing, a little under a year from institution. That initial determination is then able to be reviewed by the full 6 commissioners before it becomes final. So an initial determination, while persuasive and likely to be affirmed in large part, is not final until the ITC actually issues a final decision. And at that point, the remedy goes into effect. And that's a big difference between the district court and the PTAB, where the remedy doesn't really go into effect until all appeals are exhausted here. And we'll talk about the effect that an IPR can have on this. But generally, if the ITC issues an exclusion order, that exclusion order goes into effect and is not stayed pending appeal. I just mentioned this, so I don't need to get into the details, but before an initial determination goes final, the full commission has the opportunity to review it. And so often they will affirm, but with modified reasoning. So if they didn't like the way that the ALJ described something, they can rewrite that part of the opinion. They have a lot of discretion in what they can do, but they can also just affirm the ALJ's decisions wholesale or deny them wholesale and completely reverse. And then finally, ITC cases are directly appealed to the federal circuit. One thing that's a little bit unique about them is because the agency is technically defending the commission's opinion on appeal, the ITC is the party to the appeal. So as an example, if you were the party who was the complainant and you successfully defended your patent against an invalidity challenge in the ITC, and the respondents then filed an appeal to the federal circuit, the ITC would be the party defending the validity of your patents unless you intervene. You don't necessarily have a right to intervene, but it's very, very traditionally happens, and everybody pretty much does, so that you can actually defend your own patent on appeal and you don't need the ITC's office to be doing it for you. They'll still get time at the oral argument for the federal circuit, and they're still a full party to the appeal that files briefs. But in general, you have to intervene in the appeal to be part of it if you were successful below. Okay, and with that, we're going to get into some more of the specifics of the presentation, and specifically here talking about the institution of IPRs when there are pending ITC investigations.
All right, so what happens to a petition, an IPR petition, for example, when there is a parallel ITC case? So as we discussed before, the board has discretion under 314A to deny a petition. This discretion is broad, as we mentioned, and institution decisions are final and non-appealable. So that's very important. On the next slide, what we have here is we mentioned the 6 factors that the board uses when determining whether or not to use its discretion under 314A. These factors are referred to as the Fintiv Factors, named after the case through which they were promulgated. The Fintiv Factors, you can see them here 1 through 6 on slide 24. And while there's plenty of discussions to be had about each of them, we're just briefly going to note a few things about these that make them relevant to what happens to IPR petitions when there's a parallel ITC proceeding. So as to the first factor, the ITC rarely grants stays. We'll get into that some more, but for now, just note that the ITC effectively does not stay investigations for PTAB proceedings. So factor 1 weighs typically in favor of patent owners. On the second factor, the ITC's short 16-month typical time frame is hard to beat at the PTAB. So the PTAB will rarely finish before the ITC, and therefore factor 2 typically weighs in favor of patent owners as well. For similar reasons, the ITC case will usually be well into discovery period by the time institution decisions are rendered, rendering factor 3 typically in favor of patent owners as well. On factor 4, if the IPR grounds overlap with invalidity grounds raised at the ITC, that also weighs in favor of denial. Stipulations can be used to get around this, whereby the petitioner agrees to the statutory estoppel in advance of the final written decision. We'll talk a little bit more about that later. But by and large, if there's any overlap, it typically weighs in favor of non-institution. Factor 5 is usually satisfied. You have, if an IPR is raised following an ITC action being filed, it's usually between the same parties, and this is often the case, this should be non-controversial in most cases. On factor 6, these other circumstances can include things like efficiency and utilization of the board resources. And so in close calls, this can also weigh in favor of denying the petition. So on the next slide, we have Connor's going to take us through a few examples of IPRs getting denied.
Yeah, so we'll go through a couple of cases where the IPR was denied institution, and then a couple where the IPR was granted institution, to talk about how these cases differed. So the first case we're going to talk about is Google versus EcoFactor. Obviously, there was a pending ITC case between these parties. Google filed IPRs, and the PTAB denied institution of those IPRs. And in particular, we're focusing on one decision here from November, where they went through the 6 Fintiv factors and found factors 1 and 2 weighed heavily against instituting because of what Phil mentioned, the fact that there was no stay even requested, and that the fact that there were also state district court cases that were waiting for the outcome of the ITC case to be fully resolved didn't bear on this question at all. And that was a kind of novel argument that Google had made, that, you know, there may be an ITC case, but there are also district court cases that will be very strongly affected by the outcome of the IPRs. And the PTAB didn't buy that. They focused on the fact that there was an ITC case going on where the parties were making huge investments getting to this trial. And so they kind of disregarded the district court cases. For factor 4, they found that the same primary prior art reference was at issue in the ITC, but because there were additional claim limitations that were challenged in the IPR with different limitations, that weighed in favor of institution. So it wasn't like claims 1 and 2 of the patent were asserted in the ITC and then also challenged in the PTAB. There were several claims that were not being asserted in the ITC that were challenged in the PTAB. And so because of that additional claim scope, that weighed in favor of instituting and having the PTAB decide the patentability of these claims. On balance, though, the board found that because 4 factors weighed against institution and only this 1 factor weighed in favor, that institution should be denied in this case. And notably, Google moved for rehearing of this decision way back in December of 2020, and that has not been decided yet. So while it's possible that the PTAB could do something different here, it doesn't seem likely given the fact that since this November case, there have been many other cases following the same reasoning. Another example of an IPR being denied under 314 because of a pending ITC case is Fitbit versus Phillips. It had a similar set of facts to the Google case, so I won't go through all of that. But the PTAB again denied institution under 314, finding factors 1, 2, 3, and 5 all weighed against institution. An interesting note on this case is that the board looked at the merits of the petition too, under factor 6, but they found even though the merits weighed in favor of institution, the fact that the other factors weighed heavily against institution meant that they weren't going to institute. So kind of a takeaway from this is even if you put together a really strong petition, if there's a pending ITC case that's very far along and you don't do some of these things that we're going to talk about later on that can help the PTAB justify institution, it's probably going to be denied. And here also, Fitbit tried to get the precedential opinion panel at the PTAB to look at this and review the Fintiv factors. They chose not to do that in June of 2021. So this case is now final and non-appealable because it was an institution decision. Now, there was a long trend of cases being denied institution when they were pending ITC cases, but recently people have started to find a way around it. And one case in particular that we've been watching is Ocado versus Auto Store, where there's an ITC case and a bunch of pending PTAB cases. There were 5 patents asserted in the ITC, and Ocado quickly filed PTAB petitions on all 5 within 10 weeks of institution of the ITC case. In all 5 proceedings, the petitioner filed a stipulation in the ITC and at the PTAB that said if the PTAB institutes these cases, then we won't raise the same grounds or grounds that reasonably could have raised in the ITC. And so the first 2 IPRs that were filed on 2 of the patents got instituted, despite arguments that 314A should preclude institution. The board relied heavily on this stipulation, and it's called a Sotera stipulation because that was the first case that someone tried doing this. And it seems to be very effective and a good way for the PTAB to kind of get around the Fintiv factors if they think that there's a strong petition. Interestingly, the next 2 IPRs that were filed were denied institution, but they were not denied institution under 314A. So the board did not look at the ITC case and say, okay, we shouldn't institute because of that. Instead, they used 325D, which allows the board to deny institution if the art raised in the PTAB is the same or reasonably the same as the art that was raised during prosecution. And so those patents were denied institution. And then finally, the 5th patent that was challenged was actually in a PGR and not in an IPR. And the institution decision is due in 5 days from now and hasn't yet been ruled on, but the petitioner tried to voluntarily withdraw the PGR because they said, we want to be able to litigate the patentability of these at the ITC during the trial, which is actually happening right now as we're speaking. And the PTAB denied their request to voluntarily withdraw because they said, basically they'd already made a decision and they were going to mail it out in the next 2 weeks. So they're in a little bit of limbo here because they're not sure whether they're allowed to litigate the validity using the grounds that they could have raised in the IPR during the trial that's ongoing. And we'll have to report back on how exactly that plays out. Turning it over to Khue here for a few kind of takeaways on this.
Thanks, Connor. So after having heard all of the stories and what the cases before the PTAB have taught us, the question is, if you're a petitioner or a potential petitioner, what do you do? Presumably, in this context, that petitioner is also a respondent in an investigation in the ITC. And in light of the Fintiv factors, we've seen, the board is supposed to, and normally does, conduct a review of all 5 factors and then does this sort of balancing test. There's no sort of formulaic way that the board has gone about conducting this balancing test, but I think that a couple of things, certainly in the recent decisions and in the Ocado decision, perhaps in particular, make inescapable is the conclusion that the stipulations play a very significant part. You can pair that obviously with factor 2 and the diligence. You can even pair it with factor 6 in the instance where the board bothers to look at the merits and determine whether the merits weigh one way or the other. But it seems to be that a stipulation that sort of takes off the table the concern that the PTAB has articulated several times about duplicating efforts or leaving open the possibility of inconsistent results. Filing a cetera stipulation or stipulation of any kind will really weigh heavily, I think, in favor of getting your petition instituted. As with everything, there's a downside to that as well, right? The stipulation means that you are foreclosed from bringing in another forum, including the ITC, the ability to assert probably any predictable 102 or 103 patent or printed publication invalidity argument. That is a big concession that needs to be weighed carefully by any petitioner respondent. But the potential benefit is you could get all the claims canceled, which of course, even if you're on the heels of an exclusion order, could be a matter of life and death for your client. And so that is one of the things that has become increasingly in vogue, the stipulation. There's another point here on this slide talking about weighing the actual cost, the dollars and cents costs. And there are filing fees associated with IPRs that don't exist in the ITC. Of course, you bear lots of other costs in the ITC, just kind of defending against it as a respondent. But the tens of thousands that it would cost you to proactively bring an IPR could pay dividends many times over if your final written decision, assuming appeal, cancels any of these asserted claims. And even if you're in the midst of an exclusion order, you can stay that ITC remedy if you get claims canceled. So that's a significant consideration. Next slide. What about if you're the patent owner and the complainant in the ITC? How do you avoid or evade your patents getting instituted in a PTAB proceeding, in an IPR? Well, you do have the general ITC mandate in your favor, insofar as the ITC, as a matter of routine, will refuse a stay. And so factor 1, I think very predictably, if you're a complainant, will weigh in your favor. And then it's a matter of strategizing when you bring your complaint to best situate yourself if you're expecting the respondents to file IPRs. This can become a little bit more predictable if, for example, you've been in talks with potential respondents. If there's been any kind of discussions with them, it could very well be the case that as you're gearing up to potentially bring a complaint, they're gearing up to bring challenges in the PTAB. So if you're a patent owner, you might want to think very carefully about what patents you bring forward in your complaint. Maybe you add one that wasn't part of the talks, maybe something that the potential respondent or future respondent perhaps didn't see coming or weighed a little less heavily. You can also tailor your complaint to give yourself the best shot at a very fast moving ITC, and the pressure of an impending exclusion order might work in your favor. But of course, there's a balancing act on that too. If you bring too many claims or too many patents that might slow you down. So as a complainant patent owner, with respect to the ITC proceeding portion of it, I think bringing the complaint, marshaling up the patents that you're going to assert, balancing it against what the respondent might be able to predict and get ready for is one side of things. On the PTAB side of things, if a petition or petitions are filed against your patents, then it would probably be in your best interest to put a lot of effort behind the POPR, or the patent owner's preliminary response, because that's your shot at foreclosing institution altogether and just sort of nipping the proceeding in the bud. And you can certainly raise the Fintiv factors as the patent owner. You want to impress upon the board all of the factors that weigh in your favor. And even though it's factor 6, and even though it hasn't played a prominent role, putting forward a good, solid case that there should be no institution from a merit standpoint could also be the thing that winds up tipping the scales. And then obviously there's the issue of whether or not you want to bring a proceeding in the district court as well. As Connor had mentioned previously, cases are often stayed for IPR, and they're also stayed if you're in the midst of an ITC investigation. It's generally a longer timeline. It does afford you damages, or the potential for damages, of course, but it's a third front that probably is going to lag both of the other two. And with that, I think we're going to sort of move our way towards wrapping up by just talking about impact of IPRs on ITC.
Cases that are part of the calculus for whether you should bring them or not. We've talked a lot about the estoppel effects, so I'm not going to go back into that. We put some case examples in the slide of how this plays out. In general, it's fairly rare for the estoppel to happen during the ITC case, just because the timelines are so close that you usually won't have reached a final written decision before the time when you'd be estopped is. But it can play out on appeal, and it can play out in some other circumstances where IPRs are filed before an ITC case. And then finally, the kind of important takeaway is this finality point, where which proceeding finishes first can play a big role on how the remedy plays out. So if the IPR reaches a final written decision before the ITC reaches a final determination, the ITC has historically suspended enforcement of the exclusion order pending appeal. And so this is basically the gold standard of what you can do if you file an IPR very quickly and manage to get your ITC case slowed down or extended. If you can get an IPR canceling the claims asserted in the ITC before the ITC fully issues its exclusion order, they'll usually say, okay, these claims have been canceled. Let's stay this pending appeal and let it all play out at the federal circuit before we start excluding products at the border. On the other hand, if the IPR final written decision comes after the ITC usually does not stay or suspend its exclusion orders. So you could see a situation where the ITC issues a final determination today. Next month, the PTAB says these claims are unpatentable. Then the respondent comes back to the ITC and says, hey, the PTAB said these claims are unpatentable, so stop excluding my products. The ITC generally says no. Both of our decisions have to go up on appeal. Neither are really final until the federal circuit weighs in. But because we got here first and we issued this remedy on patents that we found valid, we're not going to defer to the other agency here. And we have some examples of how that has played out in the ITC and the PTAB on the slides. But I think in the interest of time, we'll leave a few minutes for questions here at the end.
Hello, everyone. This is Ashley. I want to thank everyone for especially Khue, Phil, and Connor for making the time. I know that they're really busy practitioners, so we really do appreciate that. So we have a Q&A, and if anyone has questions, you could type in the chat, or, so that we could read it for you, or if you wanted to unmute yourself, feel free. I think that you guys must have addressed everything perfectly. And so if there's no questions, I want to thank Caitlin for helping me to make sure everything goes really smoothly, and the VPG team for helping us with the marketing and the animations, everything. So I think that we are right on time. Thank you again, everyone, and have a great afternoon.